regard to the intersection between federal and state law around Controlled Substances Act, and mostly so far the litigation that I've been involved in was around medical marijuana. And we litigated 2 cases along with a bunch of other lawyers. Joe Elford from the Americans for Safe Access is going to be on the second panel and was deeply involved in the San Diego County case that the ACLU worked on with those guys. And so let me talk about that case for a second and sort of help frame some of these issues. In San Diego, we didn't have the federal government coming in and seeking an injunction. In fact, what we had, and what I think is perhaps more likely with Prop 19, is local government officials unhappy with the ideas of this kind of reform, trying to shut it down in court.
So would this mean then that the local jurisdiction, say San Diego County, would bring an action and use federal law as the argument?
I suspect so. I think that that is what happened in the San Diego County case. The county argued that it did not have to provide medical marijuana ID cards to patients as state law required because federal law trumped state law. In very broad brush strokes, that's what they were saying. Now, I think the Prop 19 folks have addressed in a preemptive fashion some of that. The potential for that kind of resistance by setting up a system where the default, if the initiative passes, the default will be that while personal possession, cultivation for personal use and personal use by adults will be legal throughout the state, that any sale of marijuana will remain illegal unless and until local governments, city and county governments, pass their own local regulatory schemes that will allow it.
So again, this is the default. It sounds a little bit like alcohol prohibition.
In that
you can use it, but you can't sell it unless the county says you can.
That's right. That's right. And so, and you can grow it. You can grow it up to, I think it's 100 square foot, 25 square foot individual plot. But so perhaps that would make it a little more difficult for local government to complain. But I think that would still be where you would see the first lines of resistance. In San Diego County, the problem with their theory and the reason that we prevailed in the trial court, in the Intermediate Court of Appeal here in the state of California, and the U.S. Supreme Court denied cert, refused to review the favorable decision we got in the Court of Appeal. The reason for that, the problem with San Diego County's legal theory, and I think this goes to the heart of the discussion here, Roger, is that the state law doesn't purport, the medical marijuana law, Prop 19, does not purport to change anything about or to put up any kind of a shield against federal enforcement of federal law. The federal government can continue to enforce. Now, this is going to raise all kinds of practical problems, perhaps, as it has in the medical marijuana realm, where you have DEA raiding folks who have the blessing and sometimes active support of their local political structure. But the way the Controlled Substances Act is written, it purposefully does not, expressly does not, occupy the field. It leaves to the states authority to create their own regulatory systems and their own criminal law systems for dealing with controlled substances. And the reasons for that, I think, are both political and practical, and it has a lot to do with enforcement. I mean, the federal government doesn't have the willpower or the money to be enforcing all of the drug laws across the country as the sort of first line of defense. Upwards of 98, 99% of all the marijuana arrests in the country occur at the state and local level, not by the federal government.
Let me throw out a question then to Professor Kreit. You're saying, Alan, that, okay, as a practical matter, it's state law, state enforcement, and so forth, and yet we still have this fundamental legal conflict. And so if the federal government wanted to and had enough agents, it could go around. So, Alex, what do you, we can't continue to go on with this issue unresolved. I mean, is it just a question of Congress having to amend the Controlled Substances Act?
Well, what I think is, I think there's, the way I look at Prop 19 and what might happen is I look at it in 2 sort of chunks. The one is what I would call the decriminalization aspect of Prop 19, the aspect that says people can possess up to 1 ounce and cultivate 25 square feet. That aspect, I think, will be nearly impossible for the federal government to interfere with for 2 reasons. One, I don't think that there's any serious argument that they could raise that federal law would preempt state law in that area, because the state clearly has the power to decide what it wants to make criminal or not. And I, there's just, if the federal government tried to tell a state what to make criminal, that would run into 10th Amendment problems and be an anti-commandeering problem. The Supreme Court has held basically the federal government can't come to a state and say, you need to use your state resources to make X, Y, or Z criminal. So there's that aspect of it. What the federal government could do, theoretically, for that aspect of Prop 19 is to enforce federal law, right? And so that's the notion that they could, in theory, say, well, it's still illegal to possess marijuana, cultivate marijuana, no matter what the amount under federal law, so we're going to go in and arrest folks. But as Allman said, the percentage of people who are arrested and prosecuted under federal law for possession of small amounts of marijuana is, it's infinitesimal. I think there was something like between 600 and 900 cases at the federal level for marijuana, simple marijuana possession that went to conclusion in the last, I think it was 2009, 2008, the last year there were statistics available. And the large majority of those cases are almost certainly ones that pled down from more serious charges. People who, really would not have run into federal officials but for some other issue. So the federal government is, I think, absent a dramatic change in the way federal resources are allocated, just unable to.
I understand this. I'm just, from the practical aspect, yes, and I'll have Professor Hirshon address this. Yes, the federal government doesn't have the agents to enforce it. Most of the activity, criminally and so forth, is on the state level. And yet, if a case is brought and makes its way to the Supreme Court, today, the Supreme Court would have no choice but to say, California, you can't do that. It affects interstate commerce to the extent that it violates the Controlled Substances Act. And it's not about commandeering, I don't think.
I'm not sure. It's an argument on the basics of federalism, which sort of states' rights going to the federal government, what can and cannot be done. And you have 2 constitutional precepts here. You have the Supremacy Clause, the role of preemption, which Congress can legalize private activity banned by the state. Okay, the Supremacy Clause says you can do that. The state says something's illegal. Congress, federal government says we're going to legalize it. No issue. All right. This is a little different because the question is, can Congress ban a private activity legalized by the state? Okay, sort of the first, and then you get into what would just be referred to as the anti-commandeering approach of the court. I'm going to take a step back, if I may, for a minute, Roger, and say I've become a little cynical about the Supreme Court. I know I should say that as the former president of the American Bar Association, but let me put my cynicism out there. For years, we've been beaten with the concept of activist judges, and that's supposedly a code name for judges on the left. Activism can be on the right too, and if anybody doesn't think that's the case, they ought to be reading some of the opinions of this Supreme Court and the previous Supreme Court of the last couple of years. I happen to think, and I'm just going to throw this out there's going to be some outcome determinative situations where basically I've looked at this, and there are a number of lawyers. So I'm going to throw out a couple of sites because I think these are articles that people ought to read if you're really interested in these doctrines that I've espoused. One of them is a Vanderbilt Law Review article, Robert Mikos, in October 2009. The limits of supremacy, medical marijuana, the state's overlooked power to legalize federal crime. And Professor Mikos makes a great case in this law review article just a year or so ago of why it's going to be okay. In researching it, I happened to find my own dean had written an article in June 1995 when he was a professor at UCLA talking about state sovereignty, subordinates, make Congress commandeer state officers to implement federal law. And, you know, it's a lot closer. So if you assume, if you read that article of the Columbia Law Review, June 1995, it was started, volume 95, number 5, by Evan McKenna. If you read those two articles, you say, God, this is a really tough issue. And that's where I throw in the outcome determinant.
So in other words, the Supreme Court will sort of pick and choose where states' rights apply. So if the Supreme Court doesn't like guns, gun control, then
So they did for the Brady Act.
or if they don't like violence against women, or whatever I understand what you're saying.
Yeah. And that's what I think is ultimately going to be what's going to
I
happen.
guess what I'd like to do is call up Rob Raish now, because the Raish case, when it was decided, it was, again, it's almost as if the court had no choice, although I think it went, I don't think any Commerce Clause case has reached so far into our, literally, the functioning of our bodies, where the non-commercial exchange of a small amount of marijuana for medical purposes was deemed to affect state commerce so much that it was deemed impermissible under federal law. And so I'm just going to throw out the argument that I don't see any difference, no matter what a state can do, and no matter what political practical decisions might be made not to enforce it, that we still have the same situation that California was in at Prop 19. Rob, why don't you come on up here, I'll have you sit next to us, whatever comments you have. Rob was involved with the Supreme Court case. We invited Randy Barnett, who was the counsel, and he's, I'm not sure what he's busy doing in the East Coast right now.
Well, thank you. First off, with regard to the Rape Supreme Court case, I think part of the reason Justice Stevens